Today on the HopeFilled Financial Podcast, we're going to be summarizing almost everything you could want to know about the Secure Act 2.0. While many of the changes have already been realized, there are more coming down the pipeline in 2025 and 2026 that can impact you. And we're going to cover all of it, from my very favorite change at the beginning of the main topic through to the changes that are seldom mentioned on any other show or podcast. And to get things warmed up today, I'm going to tell you about one of the most frustrating changes I tried to make in my personal financial life that would have been completely different had it happened after the Secure Act 2.0. Good morning and welcome to the HopeFilled Financial Podcast. My name is Jay Disberger, your one and only HopeFilled Financial Coach, and I'm happy that you're here with us today. It might feel like it's only been a week for you if you're a regular listener, but it's been a long time since I've been able to record. I've been sick with walking pneumonia for over the last month. Now that I'm back, I'm here to tell you about a story that began about 3 years ago. Here's where the story begins. My in-laws had done a great job saving for my wife's education, her college education. They had a 529 and an ESA set up for her. And while my wife Amanda had gone through and utilized all of her 529 monies, there was still around $5,000 of unspent money from the educational savings account, the Coverdell ESA. This money was simply left alone after she graduated. She didn't need it because she had earned enough scholarships to get through college debt-free without having to rely on all the funds that she had at her disposal. And at the time of this recording, Coverdell ESAs require that you use all funds within the ESA for applicable expenses, qualified educational expenses, by the time you turn 30 if you're the beneficiary of those funds. And before we had any kids, we were trying to figure out what to do with this money. It was going to just basically sit there. And if we didn't have any kids, the best thing to do with it to avoid any penalties for simply withdrawing the money for non-qualified expenses would be to roll it over to one of Amanda's cousins. And this was an option we were willing to explore, but we did end up having a child 3 years ago. Oliver is our firstborn, and we decided we were going to take the money from her ESA, the unused funds, and roll them over to Oliver. This was again a fund that was set up by Amanda's parents. More specifically, her father was listed as the owner of the account. He was the executor of the account. Amanda was the recipient, the beneficiary of the ESA. And tax law that governs how these accounts function say that you can roll over the beneficiary. You can also, in some cases, roll over ownership of the fund. I didn't want the burden of managing this account to always live with Grandpa. I wanted us to be able to have ownership of it for the monies that were going to be invested for Oliver within this ESA. So we needed to roll over not only the beneficiary from Amanda to Oliver, but ownership from Amanda's father to Amanda. This is the first big road bump that we ran into in one of the most frustrating conversions in our personal financial journey. When this account was set up for Amanda, there was a little checkbox that, if checked, would have permitted ownership or management of the ESA to be transferred. This was not checked, meaning that my father-in-law was the only person who could ever manage the account. And to move ownership of the account, we would need to roll it over to another ESA that was set up in such a way that ownership transfer could be completed. And where this account was set up, they did not want to set up more educational savings accounts. They were looking at only setting up 529s. So they were not willing to open another educational savings account at all due to this new policy. So an in-house rollover within the existing firm wasn't going to be an option. This meant that we needed to set up an account outside of that firm in order to roll things over. But to roll it over outside of that firm, the beneficiary and the owner needed to be the same. Because of Amanda's age, we could not set up a new account with her being the beneficiary and her father being the owner. We could only set up new accounts with Oliver. Thankfully, the beneficiary could be rolled over because that couldn't be locked out. You're starting to see maybe the sequence here that we had to go through. The existing account was still owned by Grandpa, and we moved the beneficiary from Amanda to Oliver. After that, Amanda's father had to open up an ESA where he was the owner and Oliver was the beneficiary. And when it was set up, he had to make sure that ownership could be transferred. And because they weren't willing to set up a new account within the firm that worked like this, he had to set that up outside in another account. And this was set up as strictly transitionary because we had a brokerage where all of our other retirement investment accounts lived. We wanted to keep the ESA there. And that's not where my father-in-law was set up. Okay, so he rolls over the beneficiary to Oliver. Then he moves it over to a new account where ownership can be transferred. Ownership is then transferred over to Amanda after a great deal of paperwork, phone calls, and coordination. Okay, so Amanda now owns an account with Oliver as the beneficiary that can be rolled over to an outside brokerage, the one that we wanted, which is going to remain unnamed because I'm not sponsoring any one particular brokerage or approach. This show is not sponsored. We rolled that over and finally had it set up, so we thought. The brokerage where we had set up an account with Amanda as the owner and Oliver as the beneficiary did not take right away and didn't engage with the GUI interface until we made some more phone calls and reconciled some questions that the brokerage had because of the unusual circumstance in how the rollovers were occurring. And at long last, after about 5 months of hassle, we got everything moved over. We avoided any withdrawal penalties. We avoided any issues with Amanda turning 30 and then having to take out all of the funds for unqualified expenses. And we got our son set up, our oldest set up, with plenty of money for his educational savings account. Now, we could have saved a lot of hassle by moving this over to a 529 right away, which would have had different rollover rules and wouldn't have had as many steps, potentially. But I wanted to maintain the integrity of an educational savings account because you can always, at this point, roll an educational savings account over to a 529, but you cannot move a 529 back to an educational savings account. And depending on your state's laws, you can use the ESA money for qualified expenses that are not qualified under a 529. In my particular circumstance, in my particular state, we're trying to utilize the educational saving account monies in part for homeschooling curriculum expenses for the books and the homework. Under an educational savings account, the rules, to my understanding, and this isn't tax advice, would be you are permitted to take monies out to spend on books and materials associated with private school, and the interpretation of private school can be extended to homeschooling in some states. This is not the case with a 529. In a 529, it's only tuition that counts as a qualified expense, not books and materials for K through 12 education. Again, not tax advice. Before you take any action on something like this, please speak to a licensed tax professional. Okay, I've been wanting to share that story with you for a long time. If you have a frustration with rolling over educational account funds, I'd like to hear about it in the comments. And I'd also like to tell you that this story would have been completely different had we known about the Secure Act 2.0 and the changes that were going to be coming down the pipeline in the very near future. And that's what we're talking about in the main topic. For today's main topic, I'm going to be summarizing as comprehensively as I can the changes that happened because of the Secure Act 2.0 that passed in 2022. Now, not all changes within the Secure Act 2.0 were enacted the moment that it passed. A lot of these changes were scheduled out for years into the future. We haven't realized them all yet. As a disclaimer, this episode does not count as tax or legal advice or investing advice. Please see the description for a full disclaimer. What I'm going to be going through here is a list of what might be applicable to your situation. And if you hear something that does change your personal financial plan, it's your responsibility to dig into it and understand it in more detail than we can go through in a short episode that's summarizing all of the changes. We're going to organize these changes into 6 main broad categories. The first of which is going to be educational investment changes. Second are going to be the changes that are directly applicable to your retirement account contributions. Third, we're going to be going into retirement account matching changes, the ones that are going to impact the way that your employer matches your retirement investing. Fourth, we're going to be covering how the Secure Act 2.0 changes retirement distribution planning, the time and season when you're taking money out of your nest egg to live off of. Fifth, we're going to cover other changes that are broadly impactful. And sixth, at the very end, we're going to cover the changes that are seldom mentioned on other shows and articles because their applicability is very narrow. However, if you listen to this show, you might find them interesting, or they may be applicable to you. And I don't want to omit them for brevity. So we're going to tack them in at the very end. Let's start with number one. There's a big change that is applicable to the story under educational investment changes. All right, check this out. If you had a 529 or an ESA and you graduate, you don't use all the funds, you end up in the situation that my wife and I were in. We needed to roll the money over so that we wouldn't take a non-qualified distribution and pay the penalties and taxes associated with it. This was the case before. With a 529 in particular, you couldn't take any non-qualified withdrawals without a 10% penalty. But as of 2024, you can roll over up to $35,000 from a 529 to a Roth IRA for the person who is the beneficiary of the account. If that 529 is at least 15 years old. This, in my opinion, is my absolute favorite change in the Secure Act 2.0. Had this been applicable to my wife and I before we turned 30, we could have taken the money that was in her ESA and instead of rolling it over to my oldest, let's say we didn't have kids, we didn't have a child to roll it over to, we could have taken it and moved it into a Roth IRA for her. And even if we were in the same situation, we had kids and our retirement was behind, we could prioritize making sure we were putting our oxygen mask on first for her, and then work on saving for kids' college later. Saving for their education is more of an option than saving for retirement. Retirement is planning for tomorrow's needs. Saving for a child's education is saving for a future want for them, to benefit them. And this change is huge for parents who are saving for their children, for their future education. Reason being, there was a fear before that you could oversave for their education. Because if they don't spend all the money, like my wife did, what do you do with it? That money might just disappear, but you wanted it to be for your child that you were saving for. Here now, there is a spillover of up to $35,000 that can go from, if it's unused for the education, directly to funding their need for retirement savings. Think of it this way. If you're saving for a child at 22 and they roll over the maximum amount of $35,000 into a Roth IRA at age 22. By age 60, assuming a 10% rate of return on average, annualized, and a inflation rate of 3%, they could have nearly $500,000 in today's money saved up for their retirement simply because you invested for their education and they had enough left over to roll over into a Roth IRA and maximize this benefit. Now, I do want to say this rollover from a 529 to a Roth IRA does count toward the contributions of a Roth IRA. This means that you can't roll all that money over all at once. It also means that if your child is rolling money over from their 529 to their Roth IRA and they're maxing out their contributions, they're not going to be able to contribute more to a Roth IRA over and beyond that. It counts as their contribution. Still, it's a massive benefit for them to have that and free up their income to invest in other retirement accounts or pay off debt that they wouldn't otherwise be able to if they were wanting to prioritize their retirement savings. Not something that I would recommend exactly, but a situation that is more than possible. Now, before we move on to number 2 for the Secure Act 2.0 changes, I want to say for my plan, I'm going to leave the money for Oliver and Isaac, for that matter, in an ESA until they're ready for college. This will maximize my investment options within the ESA because 529 investment options are more limited. It also maximizes my options for qualified distributions. I can use that money for homeschooling expenses if absolutely needed. And as long as I have a 529 open for each of my children for at least 15 years after rolling it over, they should still be able to pursue the rollover from the 529 to the Roth IRA to the fullness of my knowledge without running into any problems. I will let you know if that ever changes. Now we're going to roll over to point number 2, the changes in the Secure Act 2.0 that are applicable to your retirement contributions. There are 3 main changes that I want to cover, and the first one becomes active in 2025, and that's going to be an increase to your catch-up contribution limit. At the time of this recording, under current law, individuals who were aged 50 or more could apply a catch-up contribution of up to $7,500 annually. And starting next year, those 60 to 63 will have an increased catch-up contribution of up to $10,000, or 150% of the standard catch-up contribution that's applicable before age 60. It should be noted that this increase is going to be indexed for inflation. This is one of the most celebrated changes of the whole Secure Act 2.0, because we're in a world where Americans are wildly undersaving for retirement. When retirement comes knocking at the door, it's basically upon you, and you don't have enough. You want to be able to invest and save as much as humanly possible. Raising the contribution limit here right after 60 is wonderful, in my opinion. Speaking of catch-up contributions, that's the second contribution change I want to talk about, and that is mandatory Roth catch-up contributions. And this change is effective 2026. Currently, and up until then, if you want to have a catch-up contribution, you could put it in either a traditional or a Roth account. But in 2026, if you make more than $145,000 a year, your catch-up contributions can only go into a Roth account, into after-tax dollar retirement accounts. I think this is to limit those who are using catch-up contributions strictly for generational wealth building so that the government can get their money earlier and avoid it going into various loopholes to help the money change hands generation to generation. I'm speculating a little bit in the reason there, but in essence, if you make more than $145,000, the government would like their cut, their taxes from that money now when you're making the contribution and they don't want to defer it. All right, let's talk about the third contribution change. This one is also effective next year, 2025. This one is about auto-enrollment for employee-sponsored retirement accounts. Before, automatic enrollment was not required of any employer. Starting next year for plans like 401ks and 403bs, employers will mandatorily have to auto-enroll you into a 3% rate contribution to your retirement account that's within their control. You as an employee, if you have one of these, can opt out of it. But this is basically saying you opt in automatically and have to take action to opt out. This is celebrated widely by economists and personal financial experts because they believe that retirement savings is going to increase, and the undersaving for retirement that we're seeing as a crisis right now is going to be partially mitigated by this automatic enrollment. If you're in a place where you cannot afford to be investing for retirement, though, you need those funds for some other critical need today, you need to know that you'll have to, if you change employment, opt out of the enrollment process for that retirement contribution so those funds are available in your paycheck. Let's move on to the third broad topic today. We're going to be halfway through after this, and that's going to be the changes to your retirement matching. The first one is a little weird. It was effective this year, 2024. It enables an employer to offer a match for qualifying payments to student loans. Before, there were no provisions to talk about matching student loan payments at all. But now, in order to help an employee save for retirement while they're trying to get student loans off their back, they are permitted, if the student loan payment is qualified, to take a matching amount and invest it for you in your retirement plan. So as you're paying off debt, you're also saving for retirement. And while this is great to have another avenue for quote-unquote free money to an employee who is working on bettering their personal financial situation, I fear that this is going to encourage people to get out of college with more student loans so they can take advantage of this kind of match, which, by the way, is not mandatory. I believe employers can simply opt not to offer this. This simply gives them the option to do it if they want to. So you shouldn't plan on being able to get one of these matches, which is a reason why you should still strive to graduate debt-free. And even though there's a contribution match here, there's a higher likelihood that you'll be employed after school by someone who offers you a normal retirement match. And if you don't have a student loan payment, you're going to free up that portion of your paycheck to invest in retirement directly, still getting ahead of the 8 ball by graduating without debt. So please don't go pursuing student loans just so you can take advantage of this part of the Secure Act 2.0. And again, that's not investment advice. That's simply my wish to better your future. Okay, the next change is a little niche, so I'm going to gloss over it real fast. This is an increase in deferral limits for simple IRAs. This is applicable to small business employers. If you want to know more about it, read up on Section 117 within the Secure Act 2.0. Basically, what I want to mention here is small businesses with 26 to 100 employees have a deferral limit increase of 1% for their matching contributions for simple IRAs. This is for a match and non-elective contributions relative to where they are now and for small businesses that continue to have fewer than 26 employees. There are other changes that happen to the simple IRA, and if you have experienced them because you run a small business or are employed by a small business, please tell us about your experience in the comments below. For now, we're going to move on to the fourth broad point, and that's going to be the changes that are applicable to retirement distributions, of which there are 4 we need to talk about. The Secure Act 2.0 has 2 changes with RMD age increases. The first one was effective in 2023, so we had it for about a year now at the time of the recording. But the second one takes effect in 2033, so plenty far into the future. Before 2020, RMDs kicked in at age 70 and a half. After 2020, the RMD age was raised to 72 in the original Secure Act. Because of the Secure Act 2.0, in 2023, the RMD age was raised another year from 72 to 73. So now you can be retired up to age 73 before the government starts saying, hey, we need you to start taking money out so we can get our cut. Now, in 2033, the RMD age is going to be raised 2 more years, all the way up to age 75. And while we're talking about RMDs, let's go into the second distribution change, and that's going to be RMDs for Roth 401ks. RMDs for a Roth account don't really make sense because they were after-tax invested dollars. You can take a distribution tax-free. But RMDs were still imposed up until the Secure Act 2.0 changed things in 2024 for Roth 401ks. So for clarity, a Roth 401k was subject to RMDs, required minimum distributions. A Roth IRA was not. But as of 2024, this year, Roth 401k accounts are no longer subject to RMDs. They align the same way that Roth IRAs do. This simplifies planning and makes plans around stuff like the rule of 55, if you remember our episode on that. This makes those sorts of plans more attractive because there are fewer reasons to jump out of a Roth 401k and roll it over into a Roth IRA. And again, I think this simply makes sense because why would you impose a required minimum distribution on after-tax invested dollars? Okay, let's move on to the third point for distribution changes, and it's another RMD one. This actually applies to RMD penalties. This is effective in 2023, so we've had this one for about a year. Before the Secure Act 2.0 change, you had a 50% penalty of the required distribution that could be charged to you as a penalty for not taking an RMD when it was required of you. That's despicable. Ever since the Act changed this, though, it's been decreased to 25%. Still egregious, but better, and there's a little bit of forgiveness in here. It can be reduced to 10% if you correct the RMD error in a timely manner. That's a little bit more reasonable, especially early on as people are just like, oh yeah, RMDs, those are a thing. Let's move on to the fourth and final change for distributions, and that's going to be related to emergencies. These became effective in 2024. Beforehand, early withdrawals were subject to a 10% penalty unless you met a specific exemption like a medical expense that qualified you for an early distribution. After, those who are participating in retirement accounts can withdraw up to $1,000 every year for blanket emergencies without penalty. However, the withdrawal can be repaid back into the account within 3 years. So it's kind of like taking a loan against your retirement account. And a real little one at that. I don't think this should give you excitement to say, I'm going to use my retirement account for my emergency fund or my starter emergency fund if you're following the Dave Ramsey plan in Baby Step 1. There are also new rules that you should be aware of for survivors from domestic abuse and survivors from federally declared natural disasters, victims from naturally declared natural disasters. These are written up in sections 314 and sections 331 respectively. So if either of those situations apply to you and you wish you could have access to your retirement funds to take care of what you're going through, please look into that, talk to a tax professional, and see what is permissible now. All right, we're almost through. We have 2 more main points for the main topic. We're going to jump into the miscellaneous other changes now before getting into the seldom mentioned ones. All right, I've got 3 miscellaneous changes that you should know about that are broad sweeping. The first one's going to be the emergency savings account. Before, there were no specific provisions for treating a retirement account like an emergency fund. But after 2024's change, so this happened this past year, employers can now offer, they don't have to, but they can, offer a savings account that's linked to your retirement account. The balance of the account is capped at $2,500 or a lower limit that can be selected by the employer. I think this limit can also be indexed relative to your income, so the limit to the balance may vary. These are called pension-linked emergency savings accounts, or PLESAs, P-L-E-S-A's for short. I, again, don't like mixing my emergency savings with investments, and I don't like giving myself permission to tap into retirement accounts for emergencies. And the limit here is still very small. A fully funded emergency fund should be significantly larger than $2,500. So I'm not terribly jazzed about it, but if you run into a circumstance where you see this in your cafeteria plan and you're enrolling in benefits, you now know a little bit more about what it is and whether or not it's something that interests you. Okay, let's move on to the second of the 3 other miscellaneous changes, and that's going to be simplification for part-time workers. I really like this one. Before, an employee needed to work 3 consecutive years if they were part-time, which is service with at least 500 hours annually, to qualify for a 401k. And now, the service of a part-time employee prior to qualifying for a retirement plan is only 2 years. I like this because this enables those who work part-time because it's what they can do, even if they wanted to work more, to get access to their retirement investing a whole year earlier. That's cool. The third miscellaneous change is going to be associated with incentives for enrollments in retirement plans from employers. It used to be an explicit prohibition for employers to offer a benefit or an incentive, kind of like a bribe, for employees to enroll in their retirement plans. But now employers are permitted to offer employees a little incentive if they jump in, something like a gift card. It's limited to small financial incentives. This change will become effective in 2025. I think this is kind of cool because for the last couple years, employers can offer you a little something to inspire you to invest for retirement. And even if it's something you would do anyway, if you change jobs from this point forward, you might look into the plans and say, oh yeah, if I enroll, I get this thing. That would, just in case they're offering something. Okay, let's wrap things up with my top 5 seldom mentioned changes from the Secure Act 2.0. The first of which is going to be related to long-term care distributions from a retirement account. In 2026, starting in 2026, for the Secure Act 2.0, you will be permitted to take up to $2,500 a year to pay for premiums for long-term care insurance. And again, this $2,500 is an early withdrawal that can come out of your retirement accounts to pay for long-term care insurance premiums. I do and I don't like this because it recognizes that long-term care insurance premiums are expensive to the point that you might want to start tapping into retirement a little bit early in order to afford them when you establish a long-term care insurance policy. The thing I don't like about it is it's almost like a Band-Aid solution here. What I would do for my personal plan if I wanted to utilize this is try to just boost my retirement savings so I hit a point of genuine financial independence a little early and know that I can lean on the accounts without sacrificing my retirement future, my ability to retire with dignity, but it enables me to pay for a premium for an insurance plan that I might not otherwise be able to afford if things get real tight leading up to retirement. All right, next we're going to talk about an incentive for small businesses to set up retirement accounts. There's now a tax credit for up to 100% of administrative costs related to that retirement account for employers with at least 50 employees. And I know you may not be an employer with at least 50 employees, but this could impact you if you work for a small company because this means if they don't have a retirement account, they've got an incentive to set it up. All right, next is something that's going to be coming in 2025. I think it's cool. I think it's interesting. It's the Lost and Found database. supposedly, hopefully next year, 2025, there's going to be a national database of forgotten, lost, or unclaimed retirement accounts to help individuals track down retirement funds that they may have forgotten about. This is kind of an administrative thing. If you've been loose with your planning and you have retirement accounts everywhere, you're trying to piece it all together at the end, this database should be a help for you. All right, 2 more seldom discussed changes. The first one's going to be changes to qualified longevity annuity contracts. I'm going to call them QLACs for short. All right, prior to 2023, QLACs were limited to 25% of your retirement account. QLACs are typically used as a way to move funds in your retirement into an annuity in order to shelter the funds from RMDs. This limit has been changed now and is raised to an effective maximum contribution of $200,000 as opposed to a relative percentage. And to my understanding of the law, the 25% cap is simply thrown out the window in lieu of this $200,000 cap, which again is a contribution cap. And the last seldom mentioned change from the Secure Act 2.0 is applicable to military spouses. All right, this is a tax credit offered to employers who employ spouses of military members. This is to help those who are traveling because they're married to someone in the military establish a consistent access to retirement investment accounts. So an employer can get an extra tax credit if they offer 3 of the following to military spouses. First is going to be immediate eligibility for retirement accounts within the first 2 months of employment. Second is going to be eligibility for matching in non-elective contributions that would have otherwise been available at 2 years of service. Those become available immediately. And this is my favorite. Employers would have to offer an immediate 100% vesting to military spouses in order to get the tax credit. I think this hopefully opens up the opportunities for those who are married to our service members to invest for retirement successfully. That's it. That is my comprehensive list to summarize the changes in the Secure Act 2.0 that are likely to impact you and some of the ones that you're not going to hear often mentioned anywhere else. What did you think of today's list? And was there anything that I left out that you think would be really important for me to cover in a follow-up? And for funsies, if you listen to the end of the episode and you have a comment section, let me know. What are you planning on doing this year for Christmas that you haven't done before? Merry Christmas, Happy Holidays, and until next week, until next Tuesday, budget bravely and enjoy your hope-filled financial future.